Hi there, this is Erica Merrill, and I'm the founder of Perfect Legal Video, and I'm very excited to have with us today attorney Jim Sorenson. He has a law firm out of Tallahassee, Florida, and they represent exclusively credit unions. And so we are going to be talking to Jim today about a book that he has recently written, and it is all about collections and how it's not really a dirty word. And so with that, I want to welcome you to the show today. Thank you so much for joining us.
Thank you, Erica. Excited to be on the show today. Excited to talk about my new book.
Absolutely. And so first I wanted to ask you a little bit about your background, and your expertise has been just working with credit unions for a very long time now. How did that come about?
Well, I really fell into it working with credit unions. I remember I was in law school, and my first interaction with the credit union was my wife. When I was in law school, my wife was a school teacher, and we had joined had started banking at a local bank, and there was a minimum fee. I don't remember if it was $5, $10 back then. But at that time, we couldn't afford it on a teacher's salary with myself and law school and all the expenses. So we ended up joining the local teachers credit union. And that was my first interaction with the credit union. By the way, a credit union I'm still a member of today, Envision Credit Union here in Tallahassee, Florida. And shortly thereafter, I ended up going to work for a law firm that one of the partners represented credit unions, and was clerking at that law firm. I wasn't working necessarily exclusively with credit unions at that time. I was doing a lot of different research and legal research and writing for various partners in that firm. But through that, ended up getting a job offer, ended up working with this partner who did credit union work. And several years ago, went out on my own and started my own law firm with my partner, Tyler. And I've been representing credit unions as a lawyer over 24 years now. And in all, probably been working with them for about 26 years, including my 2 years of being a law clerk. So during that time, I've seen a lot. I've obviously learned a lot. I've and just become very familiar with the legal issues and the legal problems that they face.
I mean, that's really great experience. And I mean, there's nothing like it. There's nothing like being in court, handling certain issues that come up all the time, and being able to know which way things are going to go under different circumstances, and being able to give those options to your clients and help them pick the right one. And I'm just assuming that's what happens. I know you're great at your job, and that you have to handle a lot of these issues over and over again.
Yes, so certainly we deal with a lot of the same issues over and over again. Often I tell my clients, they'll come to me and say, I've got a strange situation. And 9 times out of 10, it's a situation I've seen before. There is the occasional, wow, that is new. I've not quite seen that situation before. And so, yes, that experience obviously helps me, because I've usually dealt with the issue before. I've helped a client resolve it before, and know how to help them navigate whatever the problem they're facing.
I think that's great. Now, the title of your book is Collections is Not a Dirty Word. I want to make sure I got that right. Why don't you show us the book real quick?
Yeah, so the book, I have the book here, and it is Collections is Not a Dirty Word. And I was playing kind of off the idea that in today's day and age, the idea of a collector or a collections department can have this negative connotation, both inside and outside the industry. And so I kind of wanted to play off that idea, and that's how I came up with the title.
That's great. Now, what are some of the reasons that collections is a dirty word to a lot of people? I mean, I know that there are some things that might be true, and some things that are just assumed. So why don't you give us a little rundown on that?
Well, yeah, I think, it's like with any stereotype. Sometimes there might be a little bit of truth behind the stereotype or behind the common view. Lawyers often get a bad rap, and sometimes that's because there are some bad eggs out there who are lawyers, and the same can happen in the collection industry. Um, and so, my experience is not representing or working with collectors outside the credit union industry. So I'm speaking exclusively from the credit union industry. And I think, one of the things that comes to mind, obviously, is this idea of collectors doing something shady, in it for the money, don't care about the person who's going through the hard time. And that is not my experience with credit unions. Credit unions have a philosophy, and this is a well-known philosophy in the industry of people helping people. And one of the things that makes credit unions unique as or different from banks or other financial institutions is the fact that they are member owned. They're cooperatives, meaning they are owned by the members, they're owned by the customers of that credit union. There aren't stockholders, there aren't shareholders in it. And so it is a different philosophy. When a credit union lends money, you're borrowing from your fellow members. And when credit unions got their start, I use the example of my wife being a school teacher. A lot of the initial credit unions were just like that. They were school teachers who got together, or they were telephone company workers or utility company workers who got together and started a credit union to provide a way for peer-to-peer lending, if you will. And so one of the things with credit unions is always, it's not a big organization. It's not often a faceless organization. It is an organization that cares about its members and is trying to do what's best for the total membership.
Wow, that is a really great explanation, and I'm not sure that everyone has heard it explained that clearly before. I didn't realize that was the history of credit unions, and I think it's just great. So let's talk about what are some of the goals of a collections department then, now that we know what the background is and whose money you're borrowing.
Yeah, so I think one of the things that in writing this book is, over the years, besides just representing credit unions in court, representing them in bankruptcy court or state court, what I've also done is gotten into where I provide a lot of consulting. I go in and help a collections department. And from time to time, you'll have a credit union that is having a problem. Their collection department is not performing properly, is not being effective. And we've come in, myself and my team have come in to help those credit unions. And through my years of doing this now, one of the things I've constantly seen is a lot of times there's not a clear goal within a collections department. And if you know anything about business leadership, businesses should have goals. And a lot of times the credit union as a whole has a goal, but what is the goal of a collection department? And sometimes it's not well focused. So one of the things that I've developed, and I think all credit unions have these goals. They may call them different things, they may word them different, but I do think these are the goals of an effective collections department. And this is something that I speak on quite often. But I think there's 4 parts to the goal. I think the goal is to reduce losses due to delinquency, reduce losses due to bankruptcy, to protect the credit union from unnecessary risk, and then to be cost effective. I think the goal has those four parts. And in that goal, or looking at that, there's some tension there. I always talk about, if all your concern is reducing losses due to delinquency, then you might have people who act reckless, act outside the law, or incur all sorts of expenses trying to chase a dollar. And that's just not it. You've got to balance it. You've got to work to keep delinquency down, but you've got to do so within the confines of the law, best practices, and being cost effective. So my whole chapter in the book on goals is all about making sure the department as a whole has a laser-like focus on what are we trying to accomplish. It's not just keep the delinquency at a certain rate. There's more to it than that.
So that's really good to know. I mean, and knowing that there are goals, and the goals are really to help make sure that the credit union survives and thrives even. And if you have a bunch of bad loans that aren't being paid, then you can't really help anybody else because you're not financially stable. So this is a really a good reason to have collections departments working like a well-oiled machine. And so now I would love to ask you, is it like, it's not like the wild, wild west, I would assume, where, sometimes it gets, that stigma, but what are some of the policies and procedures and processes involved in a well-run collections department?
Good question, Erica. One, it isn't the wild, wild west. There is a lot of laws. And one of the things that has changed in my 24 years of representing credit unions and helping them with collections, bankruptcy, foreclosure issues is the fact that there are more laws. There's more state laws, there's more federal laws that limit or provide guidance on what they can and can't do. And so, having a good policies and procedures within a collection department has become so crucial. When I first started representing credit unions 24 years ago, most collection departments would have a collections policy. It was something that was required by the regulators. It might be 3 or 4 pages, maybe 5 pages long, and they might have a 10-page procedure. Now, a well-oiled collections department, as you refer to it, would have really need procedures that would cover all sorts of things, and in many cases, those procedures and processes could be more than 100 pages of written material that guides the department on how to handle all sorts of matters. And so one of the things we do is review their policies, review their procedures, review their written processes, and help them refine them, make sure they're in compliance with the law, make sure that they follow best practices and are up to date.
Okay, well, that's really good to know, because that will hopefully put some minds at rest and at ease, because it is looked over by the law, and if things are not being done properly, then I'm sure that those things will be rectified. So that's really good to know. Can you tell us a little bit about queues and how you could use those to help organize a collections department?
Yeah, so queues are a common tool within the collections world, and they are when we refer to queues in the collection world, what we're talking about is a group of accounts that a particular collector or maybe several collectors are working, and queues have been used for a while now in the collection world to kind of organize the work. But what I find often is the way queues are organized or the way queues are laid out don't always make sense given the goals of the department or given the experience of the team. And so one of the things in working with clients, I'm not a believer, and it's a one size fits all approach. I don't believe every credit union is going to organize their queues the same way. A smaller credit union is going to look different than a larger credit union. And then there's going to be differences depending upon the number of loan products you have or the how diverse your loan portfolio is. So there's a lot of factors that play into it. And the other factor that I think plays into it is really goes into the depth of training and experience of your staff. So, one of the things we will do is work with our clients on how are your queues organized? Do you have them organized or set up to get the most out of your team, to be most effective in managing those delinquent accounts? And again, I don't take the one size fits all approach. What I might recommend or what might be best for client A is going to be different potentially for client B or C.
That's really good to know that it's a tailored solution that you're looking to help your clients obtain what's best for them. Because certainly, as you mentioned, larger organizations are going to have different priorities and different processes to make them successful than maybe a smaller credit union. And so that's really great. It's so often that you find people trying to do a one size fits all, and it's just a disaster. So that's really wonderful. So can you tell us? I know it's a fantastic thing to have a credit union and to lend money, but sometimes people end up filing for bankruptcy, and I'd love for you to speak on some of the issues that your clients have, the credit unions, when it comes to their customers going bankrupt.
Okay. So bankruptcy is one of those things that every credit union, every lender deals with, but every credit union deals with. And probably the one of the biggest frustrations I see with bankruptcy is often bankruptcy has this whole area of a lot of terms and words that aren't used anywhere else. Bankruptcy lawyers throw them around, or people familiar with bankruptcy, and it causes a lot of confusion. We talk about pre-petition actions and post-petition actions, and we talk about pre-petition debts and post-petition debts, and there's words like discharge and dismissal, and there's other things, non-dischargeable debt. So all these terminologies, and I think the vocabulary ends up getting people caught. If you don't understand the law, and you don't have the training, and your staff doesn't have the training or the resources, that can be a big struggle. And then the other part of it is just the fact that while bankruptcy is a federal law, and I talk about this in the book, bankruptcy is a federal law, it isn't necessarily uniform. It's supposed to be uniform, but it doesn't always work that way. And the reason why is we have all these districts around the country, federal districts that bankruptcy courts are broken into. And each district has its own rules and procedures. And then within each district, you might have multiple judges and you have trustees. And so what ends up happening is the way one bankruptcy is handled in North Florida, let's say, is going to be different than the way a bankruptcy may be handled in South Florida or in North Georgia, just to give examples. And that causes frustration because a client is used to a particular process, and then they get a bankruptcy from somewhere else in the state or somewhere else in the country, and the process is different, and they don't understand why. Why am I getting payments at this time in this case and not this other case? So part of what we do is an education, and but we're also that resource to help them figure out, why is this case going different? What can we do in this case to get the result we want? That's a lot of the frustration that I see. Now there's more to it than that, but just at the high level, those are the two high level frustrations I constantly see with clients.
Yeah, I mean, it would be nice if there was just one unilateral way to handle bankruptcies. And so that way everyone would know what to expect, except saying, oh, you're in this district, so it's going to be a little different for you. Or I can see where that would be frustrating. And that is, I'd like to just mention, one of the reasons you need a really good attorney that understands the differences in all of the different districts, and the different laws and the gotchas. And so we'll talk a little bit about that in a minute. But let's move on to what makes sense to move on to in this interview, and that is just talking about recovery and how that really helps the bank's bottom line.
Yeah, so recovery, I have a chapter in my book on this, and part of a collections department is recovery. And when I'm using the term recovery, I'm talking about trying to collect on those loans that are charged off. So once once a loan gets to a certain point of delinquency, they have to charge it off, which simply means they're acknowledging on their books that loan is no longer an asset. And it's an accounting process that they're required to go to. But charge off doesn't end it for the credit union. There still is a debt due and owing to the credit union. And what I find is credit unions struggle with a lot of times, how do we get that money back? What is an effective charge off, or what is an effective recovery program? And what you often see with our clients is kind of a one size fits all, again, solution. They may outsource all their recovery to an outside agency. They may take a bundle of charged off debts and sell it to a third party debt buyer, or they may hand it all over to a lawyer. And in some cases, I know some credit unions, they do nothing with it. They just sit on it. And I don't think any of those in and of themselves is an effective solution. I think you've got to lay out a plan, a process, and give your collection department, your collection manager, the tools he or she needs to be able to effectively recover. In the book, I talk about a client that I worked with recently that had really no recovery to speak of. They had no recovery program or process in place. And in a very short period of time, they built a recovery team. I worked with them on this. They went from initially one individual, then they went to 2.5 individuals in this department. And their recoveries went from about, on average, about $20,000 a month to over $120,000 a month. So real success in a very short period of time. It's just a matter of knowing how to do it and having the tools and someone to help them develop the process.
Wow, those are amazing numbers, essentially helping them bring in over $1 million, which I'm sure makes the biggest difference in running a business, which the credit union is a business. And so that's amazing that you're able to help your clients get a good process together so that they can achieve those amazing results. So kudos to you and your law firm. Let's move on to talking about like some of the mistakes. I mean, if somebody doesn't have you to help them through this process and to put things in place so that they can be successful, what are some of the most common mistakes that these credit unions are making?
Yeah, I have a chapter in the book on common mistakes, and I'll hit on one or two here. I certainly don't want to give the whole book away, but the common mistakes I see. One of the common mistakes I see is credit unions' use of letters, often in a collection process. If you think about it, you're dealing with the same thing over and over again. A person who isn't paying on a debt, you're trying to get a hold of them to resolve the debt, to talk about, hey, whatever's going on, why is it that this debt's not being paid, and how can we work with you? I mean, that's really what collections is about. And so to try to get a hold of the member, there are letters that are sent out, typically called collection letters. And what happens is credit unions will use a collection letter and never have it reviewed by an attorney. And if that collection letter has in it something that's improper, something that violates the law, that letter could go out to hundreds, maybe thousands of individuals, and they're risking a lawsuit. And so one of the biggest mistakes I see is credit unions just don't have their letters reviewed to make sure that they're compliant with the law. It's not a big deal to have them reviewed by a law firm. We do that all the time for our clients. But so often I will get a client who gets sued, and I look at the letter, and we've never seen the letter. It's as their law firm. And I ask them, did you ever have a lawyer review this? No. And then I ask them, where did this letter come from? And they say, I don't know. And I'm like, that's a problem, and that's a big problem that we see. And there's a relatively easy fix. It's just something that I guess people don't think about until it's too late and they've been hit with the potential lawsuit.
I mean, in that example that you're giving us, it sounds like they could have several potential lawsuits if they're sending that letter out to 1,000 people or more. It sounds like it could be a reason to cost them a lot of money later on in law fees to try to fight all these individual lawsuits. I mean, correct me if I'm wrong, but I mean, that seems like something that could put a company out of business.
Well, it certainly could be serious. So not only could you face a lot of lawsuits, the biggest fear is you would face what is called a class action lawsuit. So one individual and a lawyer representing that individual now files it as a class action to represent a class of people who are similarly situated, in essence, all the people who got the faulty letter. And, those types of lawsuits, class action lawsuits, are very expensive to defend and can have substantial damages, meaning the credit union has to pay out a large sum. That can certainly affect the credit union's bottom line. It could affect the survival of the credit union if the class action lawsuit was big enough. But it certainly is an uncomfortable thing for a collection manager to explain to his or her boss, why were you using this letter that was so outside the bounds of the law that now we're facing this huge lawsuit where we may have to pay out hundreds of thousands of dollars to resolve this matter. That is a problem. Yes.
Wow. So this is a great lead into my last question, which is, if you were a credit union and you were trying to cut corners because business is tough and you would like to be more profitable, not having a great attorney, that is the quickest way to ruin your business and not a shortcut that you should take. So I'd love for you to talk about some of the reasons your clients work with you and why other credit unions should do that as well and follow suit.
I think the number one reason our clients work with us is because of our experience, because of the fact that we have in my team, we have more than 55 years of combined experience representing credit unions in these types of matters. So, like I said earlier in the interview, a lot of these issues, a lot of these problems, we've seen them before. We've worked with clients before. So a lot of times we've already figured out the solution. We have the solution, and it's just a matter of helping our new client or another client enact that solution. So our experience is a big deal. We spend a lot of time keeping up with the law, keeping up with the industry, keeping up with the trends. There's a lot of law firms that do collection law in the sense of just going to court, suing to get a judgment to collect money. There's a lot of law firms that can handle a motion to lift stay in bankruptcy court or handle a foreclosure. But one of the things that makes Sorenson van Leuven unique is the fact that we have the experience to work with the collection department, not just to handle those matters I mentioned, but to come in and help them with their policies and procedures, to help them with their letters, to look at their internal processes and help them, like with the client who needed the recovery department. We helped increase their bottom line by over $1 million. Those are results that speak for themselves, and I'm fortunate to have a great team that works with me to get those results for our clients.
You are fortunate. It's hard to find a good team, and you've got a fantastic team. I can speak from experience in visiting your firm and even hearing the testimonials firsthand from your clients, and they just love you and the work that you do to help their credit unions be as successful as possible. So we will talk about this book title again. I think it is absolutely pertinent for you to get this book today. We can sign up for it. But also, if you have any questions at all about how to put a good process together for your collections department, how to be more successful, if you're seeing bankruptcies rise and you'd like to know, what are some of the things that you can do to combat some of the issues, definitely give the Sorenson Van Leuven law firm a call. They are fantastic. They treat their clients like family, and they just do an amazing job. They're in court every single day helping their clients win the fight that they need to fight to stay successful, and giving them the options that are going to be the best for them. So thank you so much today, Jim, for coming in. And, we really appreciate all of the great information that you've imparted today.
Thank you, Erica, for having me. Appreciate your time. Look forward to talking with you again.
Yes, me too. Thank you so much.